this section of our very exciting meeting is entitled to the regime of islands. And as it has already emerged from previous speeches, indeed, islands are at the center of the problems and tensions in South China Sea. Indeed, there are many aspects. I will just list them in more or less random order. My panelists will put some rationale into the subject. Certainly, perhaps the key issue politically is an issue of sovereignty. There are many islands or features over which sovereignty is discussed, and from this many consequences arises. And second, we have a problem of classification of islands. Are they islands according to Article 121, paragraph 1, or islands/rocks according to paragraph 3 of the same article? And finally, from islands derive maritime zones, including low tide elevation on one side of the spectrum, archipelagic waters on the other. And finally, islands have an impact to be determined about delimitation. The current arbitration pending between the Philippines and China has been built by the Philippines around or over these questions, and we look forward to hearing a little bit more about these issues also in light of the way they are debated before the arbitration tribunal. I don't want to take away time from my friends and colleagues in the panel. I will just introduce them very briefly. There is no need to be long because you have very well done short bios in the booklet. I just say that Ted McDormand is one of the best-known Canadian and world experts in many law of the sea and also world trade issues. And he is, I would say, a frequent flyer in the South China Sea moving circus. And so he has had, indeed, first-hand knowledge of many of the issues we are going to discuss. David Anderson, of course, is my former colleague in the Law of the Sea Tribunal. We were also together as delegates of our respective countries in the Law of the Sea Convention, and he is one of the most knowledgeable persons around in the Law of the Sea. I will now give the floor to Ted McDormand.
Thank you, Tullio. I'd like to thank the organizers for inviting me into to Brussels for a few days to participate in this workshop and to meet some old friends and make some new friends, hopefully. I do want to take a second because it is a bit unusual to bring a Canadian all the way from the west coast of Canada, 9-hour time difference, all the way here to speak for 25 minutes. But I have some experience in the South China Sea going back to the 1980s, in fact, and particularly with His Excellency Mr. Agresino's colleague, Hashim Jalal. Ambassador Jalal, on behalf of Indonesia, with support from the Canadian International Development Agency, began in 1989 and 1990 the informal workshop process on the South China Sea, which at that time was the first meeting of government, acting in their personal capacities, and a small number of academics, noticeably no Americans in the early days, and only some deluded Canadians who showed up occasionally. But this was an initiative that was led by Indonesia and by the prestige of Ambassador Jalal in Law of the Sea. And through the 1990s and into the early 21st century, that workshop, and continues to exist in a slightly different way, but there's involvement. I was involved in the early days of that and then sort of dropped out of it a bit. But I have been around the South China Sea for a while. And one of the things, which isn't in my paper, but one of the things is the ups and the downs of the South China Sea. And it's worth keeping in mind that the South China Sea is not always as hot as it appears to be today. There has been periods where there has been some degree of calm. In the 1970s, you really first begin to see the issue of the South China Sea. In those days, it was all built around the myth of oil and gas, coming out of a study done by Ascop in 1969, I think it was, and countries first starting to think about the continental shelf. You move into the 1980s, you have conflict, direct conflict between Vietnam and China in the 1970s. As already been pointed out, you had the Paracel Islands, which was North Vietnam and China coming to visit and not going away, and staying on the Paracels. You had the informal workshop process, which had its own declaration, which actually precedes, but also was, we think, and we hope, and we believe to be a building block to 2002 and the Declaration on Conduct. When you get to 2002, you've had a period of some discussion, but you've also had a period of countries going out and putting outposts onto islands, and those in reefs and low tide elevations, whatever they're called, islets, islets, I'll go with that. But that was mostly in those days Vietnam, a little bit the Philippines, and of course Malaysia. So they were out there occupying in one form or another. China was not a big occupier of areas in that time period. They still had all the claims, which I can talk about in a minute, but they weren't actually out there, you know, setting up shop, so to speak, to put it in very vernacular English. In 2002, the Declaration on the Code of Conduct, or the Conduct of the Parties, was a major accomplishment of the ASEAN process and the ASEAN process with China. And what you had after that period, really for 7 years, and you can go back into the late 1990s, really, you have a period of pretty significant calm in the South China Sea. I mean, it's not a perfect world. Fishermen fish where they're not supposed to. Fishermen get caught. You know, there were incidents that you can list. But in the grand scheme of the heat of a tension moment for a political science point of view, that was not an area that was generating the type of problems that we seem to see today. But what I'm getting at is we do have to think of the South China Sea as an up and down, that there are going to be moments of high tension, there's going to be moments of calm, or relative calm. Between 2002 and 2009, we would have to call that period relative calm. That there was no new, nobody moved out to take over new features in one form or another. There was a minimal number of harassment by whomever, of one country or another. There were China-US issues, but China-US issues, as my colleague has pointed out, are different than the South China Sea ASEAN issues in the grand scheme of things, at least in the focus for the moment on the insular features. So in 2009, you see a ramping up of what's happened and what has continued to this day. So 2009, 2015, if we're on a 10-year cycle, we may have 3 or 4 more years before either the Code of Conduct comes in, an actual Code of Conduct, which is different than the Declaration. And I'm not sure if I'm hopeful about the Code of Conduct or not, but I know that there are discussions or have been discussions that have been taking place. I have not tracked this because I just don't track this on a day-by-day basis. That may calm things a little bit. It's interesting to speculate, though, because you know, what happened in 2009? Well, what happened in 2009 was the submission to the Evil Commission on the Limits of the Continent, evil being an editorial phrase, the Evil Commission on the Limits on the Continental Shelf put in place by Vietnam and Malaysia. And I think that changed the atmosphere in the South China Sea. And that's what I want to talk about a little bit, is that change in the atmosphere. But I'll go back and talk about some islands, too. By the way, if you're interested in islands in the South China Sea, I advise you to pick up, if you still can, last week's or this week's Economist, which has everything you need to know and everything I'm going to say on pages 35 and 36. It has color photos, or color maps, no photos, color maps, and it explains the South China Sea and islands in a way better than anything that I will ever even attempt. I was tempted to get to Eric to just make, and Marco to make copies and just hand it out, and we just have an extended lunch, but they told me that that wasn't going to justify my airfare. So I point that out, that's there. Now, let me just talk for a second about the islands in some way, shape, or form. As we all know, the island features, and I use the terminology loosely, the island features, or the insular features, are, in the Spratlys at least, are claimed by more than one state. We already know that. They claim exclusive sovereignty over them. In the case of the Spratly Islands, it's China and Vietnam claim all of the features. Vietnam has, to a certain extent, made public its historic documents in favor of that, at least in English. I don't know what there may be elsewhere, but there are documents support that. China has not made public any of its documents. I do not fault China for this. I mean, this is a choice of a state, and coming from a country that also has some interesting historic waters claims, we're not about to tell you what our evidence is. So, in terms of some of our Arctic issues areas. So that's not a fault on the part of China. They have opted not to. That's a choice that the government has made. We also have Malaysia. The Philippines have made some claims to some features, in Brunei to one feature, as far as I understand it. The Paracel Islands, which is another area, of course, it's China, Vietnam. China here, I'm including the Taiwan as part of China, just for the sake of conversation. It's both China's in a way. Respect Scarborough Shoal, in that area, it's China and the Philippines. So you have kind of various configurations of one type or another. We all know that international law here is based on the law of the sea, whether the law of the sea convention is the full story or whether there's customary international law. I think we recognize when we use the phrase law of the sea, it is based on the law of the sea convention. There may be other parts of that. As I tend to footnote as a good Canadian, to point out that the United States actually complies with the law of the sea convention without being a party more than just about any other state on earth, including Canada. So the U.S. is a major player in the law of the sea discussions, even if they're not a party to it. What I want to talk about in my few minutes is what have the states actually done regarding, or said, or how have they acted regarding the islands. The international law around insular features and low tide elevations, my colleague Judge Anderson will talk about that in some detail. The 2-second version is an island gets 12 nautical miles, right, and an actual island will also generate a 200 nautical mile zone and a continental shelf beyond that, where that continental shelf exists beyond that, beyond 200 nautical miles. However, if you are a rock, you're stuck to 12 nautical miles, and if you're a low tide elevation, you're stuck at nothing. The whole question in the court cases have had a lot to say about this, that you cannot even claim a low tide elevation. According to the court, at least one of the two judgments, I guess, you cannot even lay a claim to a low tide elevation beyond 12 nautical miles. Now, there's some complexity there I won't get into, and if somebody asks, I'll just feign I don't know what I'm talking about. What we do know, and what this article is actually all about, is the enhancement of the insular features. John quite conveniently provided lots of insight as to the buildup of many of these insular features in the South China Sea. The legal questions around that, can you change from can you become, one day you're a low tide elevation, and all of a sudden you've grown up, you're now a rock, and someday you'll be an island. Can you move in that sort of way? I don't have an answer for that. We have other smart people here who will probably have a better venture than I do. I don't think the Law of the Sea Convention envisioned that, but the Law of the Sea Convention was from the 1970s, so it's worth remembering the time frame a little bit. I haven't done the legal work. I know Professor Quen has done some legal work in this area, and I would respect his judgment until I form my own on that. But we know that's sort of the basic building blocks for the islands. The issue of the insular features, the issue of the islands in the South China Sea, it's been recognized. I said this morning in a commentary on John that back in the 1990s, Ambassador Jalal and that group, I mean, that was talked about, the idea of Antarcticizing the South China Sea. I mean, that was an issue that was there. One of the other things that was well known at the time was, look, if you could isolate the islands, if you could get the islands so that, okay, we'll just not so much put them aside, but put them in a box, a nice, a big box, and we'd include everything in the box, okay? If you just get the islands and just kind of put them aside, and we'll just assume that they can't generate more than 12 nautical miles. And that would be a way that the countries could step and make moves forward, because it would turn the South China Sea, instead of being this multilateral knit mess of claims and all that sort of stuff, would basically turn it into a non-ending series of bilaterals with trijunction points and some overlaps, but nowhere near the complexity of the overlaps that we now have. So that was well understood in the 1990s, that if you could accomplish that in one form or another. What I'm going to tell you, or what I'm going to suggest to you, and assert as truth, is that Malaysia, Vietnam, and the Philippines have essentially accomplished that. That what they have done, their actions, are such that their view is that none of the insular features in the South China Sea, and I'm talking mostly about the Spratlys here, but I'll include Scarborough Shoal for the Philippines, that none of those features are anything more than rocks or low tide elevations, that none of those features are subject to or entitled to a 200 nautical mile zone of their own. And this is the position, I think, if not particularly expressed by a country, it is the position that they have clearly, publicly demonstrated. In the case of Malaysia and the Philippines, it's 2009. In the submission that they made to the Commission in 2009 to do with their outer limit of the 200 nautical mile zone, they actually showed their 200 nautical mile zone. And in the process of showing their 200 nautical mile zone, you started to say, ooh, how was this measured? And when you look at first at the Vietnamese 200 nautical mile zone, you find that it's measured from their straight baselines. Now, their straight baselines, we could have a discussion, and my Vietnamese colleagues is leaving, but we could have discussions about the validity of the baselines in one form or another, but that's neither here nor there. It was from the baselines. It was not from any of the insular features at all. When you look at the Malaysian 200 nautical mile zone, it's always been difficult to detect where the Malaysian baselines are, but you can do it if you retro-engineer it, backwards engineer it, you can find that their 200 nautical mile zone was based on baselines along their coast as well, baselines that have been in place since the 1970s, although not actually ever publicized in any particular way, but you can reverse engineer it, which people do, and it's simple enough that even I could almost do it with a little bit of help. So you have, and in the case of Malaysia, it's all from the land. What's interesting there, when you look at it carefully, is, of course, when you look at the 200 nautical mile zone of Malaysia, you have within it a number of insular features that were actually occupied, actually are still occupied by Vietnam and claimed by Vietnam. So you get, and so the implication of that, never stated, is that these insular features that Vietnam claims within Malaysian 200 nautical mile zone must be only islands, rocks, and therefore only a territorial sea. It's long been the position, as I understand it, based on secondary sources only, but people who have worked with the government of Vietnam, but obviously don't speak for the government of Vietnam, that they have long held the position that none of the features in the South China Sea are in fact islands. Malaysia was never quite clear, but we've now got clarity on that. The Philippines is interesting for a whole lot of reasons, as always. The Philippines what's interesting, in the Malaysia-Vietnam submission, one of the things that was very peculiar about it was the 200 nautical mile zone they drew on behalf of the Philippines. It is incredibly, there's no other example that I could come up with, and I look at these things, okay? I don't have a good example I can come up with where you have two countries or making a submission and you draw a 200 nautical mile zone of another country that's not part of it or hasn't agreed to it or isn't a direct player here. What's interesting, so they drew a 200 nautical mile zone for the Philippines. The Philippines, of course, sent in their obligatory note verbal saying, but the area that Malaysia and Vietnam are dealing with is an overlapping claim with areas that we also have an interest in. But they did not take exception to the 200 nautical mile zone being drawn. When you look back in public, I have no other information to go by, it's quite clear that the Philippines were involved in discussions with Malaysia and Vietnam, that's on the public record, about perhaps even having having 3 countries go forward. So my guess is, without putting words in the Philippines, they must have agreed to this. The Philippines, of course, in 2009 adopted new legislation, which indicates that the KIG group, the Calayan Island group, and also Scarborough Shoal, that will all be dealt with under the law of the sea convention under various interpretations of Article 121. In the statement of claim in the Philippine-China arbitration, the Philippines made clear that the numerous features that were covered and described in the legislation that they have are, in fact, either low tide elevations or rocks. So they joined with Vietnam and Malaysia, essentially. So you go back in time, and you see, well, a number of people thought, look, if you could isolate out the rocks and get them all to be rocks and low tide elevations, you would change the dynamic of the South China Sea. And that seems to be what these 3 countries have been attempting to do. We'll leave Brunei out of this for the moment, because that's a whole different issue. But then you have China. And China's position has, in 2009, they took the view that, of course, what Vietnam and Malaysia did seriously infringed on China's sovereignty, their sovereign rights, and jurisdiction, using 3 different terms. And this is when the U-shaped line shows up. I call it the U-shaped line, but it's a 9-dotted line, whatever I prefer to as U-shaped dotted line. As it was indicated, that people knew about this in the 1940s. I can remember when Ambassador Jalal handed around an article that he had written in the early, late 1980s about the U-shaped line. It was the first time I had run into it in the early 1990s. So it was known out there, but just exactly what it represented was unclear then, and it hasn't really changed very much since then. 2009 was the first time that as you pointed out, that this was put forward in a UN body in a public sort of setting of that type. And so this first time that China really asserted the lines, shall we say, asserted the U-shaped line. What they actually assert, however, is less than clear. What is interesting, in a way, is that the foreign ministry, except in the position paper where they make reference to it, but only kind of indirectly, that the foreign ministry has made no comment that I have seen in English to the U-shaped line since 2009, which is curious. For all of the discussions that have come up, that's never been referred to again. Now, I don't know. We know it's been referred to elsewhere by other government officials at different times, frequently from the military, but not necessarily from the foreign ministry. I don't know what to read, what to read into that. I prefer to read nothing into it, except it's an observation that the U-shaped line may not have, somebody somewhere may not be as happy with the U-shaped line as somebody else might be happy with. I think that might be the issue, but I don't know. I have no way of knowing that. China has made a position known on rocks and islands, right? It did this in the context of Okinawa-Torishima. If you don't know what Okinawa-Torishima is, you catch your, stick it in your little BlackBerry thing, and see, I'm Canadian. Your little BlackBerry thing, nobody has it anymore, but if you still had your BlackBerries, you could pull it up pretty quickly. And that's the Japanese little rocket, if that's what you want to call it, that generates not only a 200 nautical mile zone, but also an extended continental shelf. And China's had some very strong words about this that has communicated to Japan and at different times. But the China's view is that that Okinawa-Torishima, whatever else it is not an island. It is a rock. Or maybe it's a low tide elevation. They say it's not. In fact, they describe it as a rock. And they say that it cannot sustain human habitation or economic life. Doesn't matter how much concrete you pour around it. Doesn't matter how you try to build it up. It is still a rock. And just in case you think that they've missed this in the Economist, they call it "You're a rock and I'm an island," and this is when they talk about Okinawa Torishima in the context of the South China Sea. In 2011, in a response that China made to a Filipino note, which we won't get into the whole history of that, it talks about the phraseology is interesting, that the Law of the Sea Convention, as well as national law, under national law, as well as the Law of the Sea Convention, China's Nansha Islands is fully entitled to a territorial sea, exclusive economic zone, and continental shelf. This has been interpreted by at least two colleagues of mine that this is the first official statement of China that the Nanshan Islands, Spratly Islands, meet the requirements of Article 121, in other words, an island. Now, they don't tell you whether it's all of them or a part of them, but they do assert an exclusive economic zone from the Spratly Islands, using the English rather than the Chinese, the Nanshan Islands. That exact wording was repeated in the position paper of the People's Republic of China on December 2014, where it says with the exact same wording. So the implication seems to be that China's views are that the Nanshan Islands, the Spratly Islands, in one form or another, generate an exclusive economic zone, which must mean that some, if not all, or part in some vague way, and I'll come to that in a second, I think, generates a 200 nautical mile zone and a shelf beyond 200 nautical miles. Although, to be fair, if the Nanshan Islands actually generate a 200 nautical mile zone, there's probably not going to be much in the way of continental shelf left in the middle of the South China Sea. This doesn't cause me any particular grief, but because in Canada, Russia, and Denmark are making sure there's not a hell of a lot left of the Arctic either. So this doesn't trouble me a whole lot when it comes to the continental shelf beyond 200 nautical miles. The position paper notes that in order to determine China's maritime entitlements on the Spratly Islands, all the maritime features have to be taken into account. Now, this is in response to the Philippine argument that only some of them should be looked at, and China says you can't isolate. You can't just pick and choose. In their view, putting words into the mouth of the arguers here, but putting what seems to be that the Nanshan Islands have to be treated as a totality in one form or another. This is not, and then you go back to what's been pointed out already, the Paracels, right, have had straight baselines. They've been treated like China as a totality. Now, there's no straight baselines around the Spratly Islands or any of those features, but nevertheless, China's view seems to be. They point out, and one of the other parts of it, which is interesting, they talk about low tide elevations, right? Low tide elevations, I think David will talk about that in some detail, but low tide elevations aren't supposed to be able to be claimed in terms of territorial sovereignty, and you certainly don't get big zones and all that sort of stuff. But China's position paper had a comment about the International Court's decision on this, commenting that the court did not touch upon the legal status of low tide elevations as components of an archipelago, or sovereignty, or claims of sovereignty that may have long existed over such features in the particular area. Now, how do you read into that? You read into that the possible argument that China will look at low tide elevations as part of that entire package in some sort of archipelagic type of arrangement. We all know the rules. We all know the Law of the Sea Convention when it comes to mid-ocean archipelagos, but there are lots of countries, Ecuador, Falkland Islands, that have baselines around archipelagos that are a long way away. So there's some interesting issues there. The U-shaped line has, and I was going to say some more about the U-shaped line, but I won't. My last two comments, very briefly, turn the paper over so I don't read it, is to just look very briefly, turn it back over, at the China-Philippine arbitration. Just 2 points, only 2 points. That's it. That's pretty short for me when it gets right down to it. First thing is there's never been an international decision that's dealt with an insular feature, low tide, call it what you want, that's been subject to sovereignty dispute. Doesn't mean there can't be, but there hasn't been. I just think that's interesting. The other thing is when you look at the wording of Article 121, it talks about human habitation and all that kind of funny wording. That's not just a physical definition. Right? Can you make it question? Can you make a decision on that if you only have one party providing evidence? Third point, I lied. Third point, when it comes to low tide elevations in one of the Nicaragua cases, they had two countries dispute it, but they actually had two countries bring huge amounts of physical evidence that showed diametrically opposed positions. Even on a low tide elevation, which you think is supposed to be scientifically based, there seems to be an ability to devise and to bring conflicting evidence by two different parties. I think I've had my say. Thank you very much.
Thank you, Ted. This was, as always, a very challenging presentation. I will now move to our other colleague, Judge Anderson, to whom I give the floor.
Thank you very much, Professor Travers. I'd like to thank Professor Franks and the University for inviting me here. It's very nice to come back to Brussels again. I've spent, as I mentioned this morning, a lot of time in this very room. Not only EC meetings, but also, I think, negotiating the boundary between the UK and Belgium in the southern North Sea. I've very little experience of the South China Sea. It's the part of the world I've not visited apart from going to Singapore. So I'm going to make very general remarks. I'm going to draw on my recollections of a time when I worked for the British government, but of course my remarks are purely personal. First of all, I'd like to say something about islands and territorial sovereignty. The Law of the Sea Convention does not apply to the acquisition of territorial sovereignty. This is true whether the territory is mainland or island. On this issue, the relevant law is the customary international law on the acquisition of territorial sovereignty, which of course is very different in content from the law of the sea. Acquisition of territorial sovereignty has to do with the activité, as we say in English these days, whether you can show sufficient evidence of administration or occupation of territory, islands included, as the sovereign. There's one qualification, though, for the law of the sea. Where a low tide elevation lies within 12 miles of the mainland or an island, then this low tide elevation may be used as a base point for measuring the 12-mile territorial sea, producing a bulge in the outer limit. This is the effect of Article 13, of course. And so then the territorial sea, including its seabed and subsoil, are under the sovereignty of the coastal state, which means that the low tide elevation itself is also under that sovereignty. So sovereignty has been acquired through the law of the sea. And this happened to us in the UK when we extended from 3 to 12 miles, and places like the Goodwin Sands became part of our base points for measuring the 12 miles towards Belgium. In situations where two or more states claim sovereignty over the same island, then there's a dispute whether or not both states acknowledge this. The Convention and the UN Charter both require the claimants to settle their dispute by peaceful means of their own choice. And this has happened in a corner of the South China Sea. Malaysia and Singapore submitted their dispute over Pedra Branca Pulau Batu to the ICJ, and they got their 3 answers. Not all islets and rocks are capable of appropriation. In the Maquis and Écreho case between France and the UK, this concerned 2 sets of features in Granville Bay, where there's a very great tidal range. I once had lunch on the Maquis, the maîtresse île of the Maquis, which belonged to Jersey. And we arrived at high tide, and by the time we left, we had to walk 200 or 300 yards down a causeway in order to get back on the boat which had delivered us there for lunch. The ICJ, in that case, was requested to determine whether the sovereignty over the islands and rocks, insofar as they are capable of appropriation in the two groups, respectively belongs to the UK or the French Republic. We both had 3-mile territorial seas at the time, and the sea probably retreated more than 3 miles. So there are some features which are not capable of appropriation. Those are beyond the outer limit of the territorial sea, 12 miles, almost universally these days. Within, you can use them. Beyond, you can't. I'll say something now about insular features and the law of the sea. Well, the Convention applies to the South China Sea just as it applies to the Caribbean, the Baltic, the North Sea, and the Mediterranean. All states parties to the Convention have a legitimate interest in the South China Sea. This morning we heard about navigation. That's completely universal. And Ted threw out the interesting idea just now that there might be a bit of international seabed area left after the national claims have been met. So all states have an interest, and they also have an interest in the correct interpretation and application of the Convention as a whole. Questions concerning the status of coastal features are governed by the provisions of Part 2 on baselines, while Part 12 lays down the regime of islands. Artificial islands are subject to Article 60. And these provisions, most of which have been held by international courts and tribunals to reflect customary law, attempt to take account of all manner of different maritime features in the wonderful world we are privileged to inhabit. The formulations attempt to describe geographical phenomena. And as we heard from Professor McManus this morning, there's a great variety of natural features, especially in coral areas such as the South China Sea. So you have to try to, the conference had to try to describe situations in words which cover a great variety of natural conditions. The provisions may not be easy to apply in certain circumstances, and you rely on the availability of cogent evidence in taking decisions. So I'd like to say something now about the negotiating history of the provisions I just mentioned. Well, baselines are dealt with in great detail in sections 1 and 2 of Part 2 of the Convention. These rules were based on two sources: the very similar rules contained in the Geneva Convention, explained by Fitzmaurice and Marjorie Whiteman and some other commentators on the Territorial Sea Convention. That was a codification based on the work of the ILC, whose report is still relevant in the interpretation today. So that was the first source. The second source were proposals by delegations at the conference. We had a list of subjects and issues as long as your arm. It was comprehensive. And at Caracas, more than 80 formal proposals were submitted. They're all in the record, C2L series. And many other proposals were made from the floor of the second committee. And then when we broke up into the informal working group, where we went through everything in great detail and lots of further proposals were made. So this was the opportunity that the UN conference gave to all states in the world to raise any special claims or problems that they had. Well, now, the Asian delegations did submit some proposals. First of all, the Philippines make proposals about historic waters. They made a formal proposal at Caracas, and they returned to the charge in the informal working group in 1978. And they tried to persuade the conference to make exception for historic waters held as territorial sea. They had a detailed proposal, which I won't read, because it was rejected. The proposals were opposed by many delegations, and they were not accepted by the conference, and they do not appear in the convention. Next, Bangladesh. They had a problem with their unstable coast in the delta. So we discussed it, and we accepted something along the lines of their proposal, not exactly what they proposed, but we gave them something in the second paragraph of Article 7. Incidentally, they seem not to have taken advantage of it. Fiji made a proposal about atolls and reef. Fiji, another atoll, another coral area. Fiji's proposal was accepted, but with the very important addition of a reference to the low water line on the atoll or reef. We made some other modifications, and the result became Article 6. Of course, this article is very relevant in the South China Sea as well as in the Western Caribbean. Indonesia and Philippines, together with Fiji and Mauritius, as we know, made proposals about the regime of archipelagic states, which had been swept aside at Geneva in 1958. Their proposals were accepted after lengthy negotiations and became Part 4 of the Convention, but it applies not to all archipelagos, but just to mid-ocean archipelagic states. China made an informal proposal in the working group of the second committee, reverting to an idea they put forward in the final session of the CBEC committee. This would allow for a combination of different methods for determining baselines. We discussed this proposal in the small working group on baselines, and we accepted it as it became Article 14 of the Convention. So these were the problems perceived in the 70s by the Asian states. They were negotiated, and they were either included or not included in the Convention. So what the Convention contains today was discussed and agreed to by all concerned not so long ago, in my memory. Now, as regards historical claims, we've heard reference to this possibility several times already today. Well, with the two well-known exceptions for historic bays and historic titles in delimitation, which were carried over from the Geneva Convention on the Territorial Sea, there was very strong opposition to any claims to preserve historic rights or to grant special treatment for historical reasons. Such claims were characterized as elements of a bygone age. Imperialism, I was charged with several times. The developing coastal states of Asia, Africa, and the Americas, many of them newly independent, were determined to put an end to foreign fishing fleets operating in their EEZs on the basis of claims to historic fishing rights. At Caracas, Mr. Warioba demanded a revolution in the law of the sea. He wanted to abolish the concept of the high seas, I remember. Well, after negotiations, the result was reform or evolution in the law of the sea, but not revolution. Developing states refused to perpetuate claims by older states, such as my own, advanced before the developing states had gained their voice in international negotiations. Most of them had not been at Geneva. So historic claims to seabed rights on the basis of occupation and administration or historic title had already been removed by the Geneva Convention on the continental shelf, since that convention had provided that the coastal states' rights were inherent, natural rights over the adjacent areas of seabed. The only trace of historic fishing rights now is found in the list of factors set out in Article 62, paragraph 3, for foreign access in that rare situation where the coastal state declares a surplus stock in its EEZ. Any further historic claims were abandoned by older states upon their acceptance of the terms of the convention. In some cases, including the UK, this meant restructuring the industry, scrapping vessels and replacing them at great cost. As regards proposals that were not included in the convention, they were not accepted, and they cannot lawfully now be invoked to seek to affect the interpretation of the provisions that were included. In the Saiga No. 2 case, the Law of the Sea Tribunal rejected an argument by the respondent to the effect that a proposal which had been pressed by the African group, but which did not appear in the convention, somehow still retained some relevance in interpreting its terms. Judge Nelson put it most clearly. He said that the argument seemed to contain within it the seeds of destruction of the convention. It would have the startling result that proposals which had not been accepted by the conference would somehow still remain like shades, waiting to be summoned, as it were, back to life, if and when required. This finding by the tribunal related to the economic zone, but the rationale also applies to the proposals by the Philippines about historic rights. If, during the long years of the conference, 9 years we spent, a state did not raise a particular claim, then it finally missed its opportunity to do so when the conference closed in 1982. The convention sets out negotiated solutions in a package deal. At the heart of this package is the agreement on limits, 12 for the territorial, 24 for the contiguous zone, 200 for the, and the arrangements for the continental shelf in Article 76. If a state which had in its official thinking some unannounced claim nevertheless became a state party to the convention, then by doing so, that state accepted all the provisions in the convention. It became too late to put forward and act upon this hidden claim. It became obliged to bring its legislation into line with the convention. And a state is not entitled to interpret the convention as if its delegation had advanced some hidden proposal which had then been accepted. The states parties enjoy many rights and benefits from the convention. They have to accept equally the obligations that they freely accepted upon becoming a party. The correct approach to the interpretation of application of these geographical provisions is to interpret them in a reasonable manner, acting in good faith. Conversely, it means avoiding claims, interpretations, stratagem, and self-serving actions that represent something of an abuse. The role of state practice in the interpretation of treaties and conventions is strictly limited. Exaggerated claims are just that. Too exaggerated claims do not change the true interpretation. There's no room for the persistent objector, since the time for making special claims has come and gone, and we accommodated several persistent objectors in adjusting the baseline's rules, as I've described, and there were some other cases. So courts and decisions have been given jurisdiction by Part 15, and it's their decisions that really count on the interpretation. I'll say something next about natural islands. Well, Ted has already been through the definition. The name is totally irrelevant, especially self-serving names. A shoal or rock does not become an island because its geographical name includes the word island or reef or archipelago in whichever language. Terms such as tidelands, they don't appear in the convention. It's best to stick to the terminology of the convention. Naturally formed means created, maintained, and shaped by the forces of nature, not by human actions. Land means terra firma, whether it's rock, granite, coral debris in one case, sandstone, sand, limestone, whatever. It does not include previously floating material that has grounded temporarily, such as ice flows or rafts of vegetation, such as those off Suriname. The term surrounded by water means that the land stands proud of the sea and has its own low water line encircling the feature. Above water at high tide means that the land remains above water at high tide. Now, there's no internationally agreed single standard for tidal measurement. Would that there were one, but the IHO seems to be inactive. It's reasonable to work on the basis that high tide means the high tide according to the chart datum of the particular state's officially recognized charts. So, if a state's charts use the lowest astronomical tide, then to qualify as an island, a feature has to remain above water at the highest astronomical tide. A low-lying island may occasionally be washed over by extreme natural events such as tsunamis or sea surges without losing the status of an island. However, if an island formed of sand or mud is washed away by high waves or extreme events or sea level rise, it ceases to be an island and it may no longer be used as a base point for measuring the territorial sea. Claims should be withdrawn in favor of current realities. At one time, Great Britain used to be joined to the Eurasian landmass. There was an extreme event, a slump off Norway. It sent a big wave down the North Sea. Whoops, we became an island. So we now have baselines as an island. So you have to take account of natural changes. You can't hang on to history when the world's changed. If a shoal or a shallow part of the seabed is built up by the deposit from a ship or aircraft of hard materials, such as rock, coral fragments, concrete blocks, old ships, or whatever, so that the feature is above the high tide line, the result is an artificial island. It fails the naturally formed test. However large it's made, however many people live on it, however long a time ago it was built, it remains an artificial island because it was formed artificially. If a lighthouse is built on a submerged rock or shoal beyond 12 miles, the lighthouse is not an island with its own 12-mile limits. In the 19th century, we built many islands on rocks beyond the 3-mile limit, and they did not have a territorial sea. If a natural feature, small and low in the water, is seen to be in danger of eroding as a result of natural forces, the construction of protective measures around it could mean, arguably, that the feature loses its naturally formed characteristic because it would be artificially protected from natural forces and not naturally maintained by those forces. I'll say something about baselines on islands. First of all, just Ted mentioned the Falkland Islands. I should make clear that the partial set of baselines there are around a deeply indented coast with a fringe of islands. They're not archipelagic baselines. They were made under the Geneva Convention rules before the entry into force of the Law of the Sea Convention, if I remember correctly. Now, I want to say something about harbour works. Article 11 permits states to build harbour works and to use the low water line on harbour works as base points for measuring the territorial sea. The biggest example, I think, is Europort. I'm looking at Lisbeth. I think Europort must be about the biggest. As well as Europort, the Netherlands and other states have built sea defences along the coast, and they have then used these coastal protection works as base points. No one has protected against this practice, and it's clearly bona fide coastal protection work. Now, there are several international airports, such as Hong Kong, Changi in Singapore, and Male, that have been built wholly or partly on reclaimed land and have runways sticking out into the sea. Male, both ends of the runway stick out into the sea, and you've just got the island in the middle. The low water line on runways such as these may form base points. They're bona fide public works. Just like a mainland, an island may have a port or an airport, and an island may need coastal protection works just like a mainland. So ports and airports and coastal protection works on naturally formed islands are capable of generating base points for measuring the territorial sea, and so on. Now, sea levels may change over the decades. As I mentioned, after the last ice age, we had the surge in the North Sea. Climate change is causing sea levels to rise, as we heard this morning. But you have to deal with this, the here and now, and take the present state of the natural conditions. So, what are the entitlements of natural islands? They have baselines and zones just like mainlands. This is the effect of paragraph 2 of Article 121, but then in delimitation they are often given less weight these days than mainlands. I come now to rocks. Some islands are small, isolated, and uninhabitable rocks. They're naturally formed and above water at all times, but because of their small size, they are no more than rocks. Well, the Convention provides they can have 12 miles and also a contiguous zone, but contiguous zone's a bit theoretical if it's a rock. But not, they can't have an EEZ or a continental shelf. When the UK became a party to the Convention in 1997, we reduced the UK fisheries zone by no longer measuring from rockall. So the UK's laws were brought into conformity with the Convention. This, I suggest, is what states are supposed to do upon becoming a party to the Convention. But I fear that some other states may not have done this, even though they claim sovereignty over what are no more than rocks. So such states are in the position of claiming the benefits of the Convention while failing to accept the obligations, and this cannot be correct. In the case between Nicaragua and Colombia, the ICJ held that Article 121 was part of customary law. The court considered evidence from geographical experts concerning the status of several features. These were atolls and keys made of coral, small in size, but there are no rules on minimum size. They were rejected at the conference, and remote from the mainland. The court held that one of these features, Quitase Sueno, was composed of a rock and 53 low tide elevations, all but 2 of which were within 12 miles. So the rock was accorded a 12-mile territorial sea, measured from the rock, and the 51 low tide elevations within 12 miles. And this case strikes me as very relevant in the context of the South China Sea. Questions of legal status should be considered on a case-by-case basis in the light of expert evidence of the facts. I come now to artificial islands. Installations, structures, and man-made artificial islands do not possess the status of islands. They have no territorial sea of their own. This is the wording of Article 60. Instead, they get a safety zone of 500 meters. Well, I've said a bit about low tide elevations already, and I think delimitation has been covered. So as time is pressing, I'll wind up by saying that the South China Sea has the status of a semi-enclosed sea. within the meaning of Article 123. This status does not affect in any way the application of the other articles of the Convention which I've reviewed just now. Rather, it calls for cooperation among the coastal states. I'm very familiar with the North Sea, where there has been close cooperation. We have a full set of agreed boundaries. We cooperated over introducing the EEZ. Adrian Boss chaired meetings in The Hague, and we did it in concert. We cooperate, of course, through the European Union as well, through the common fisheries policy, but also we have lots of arrangements, and it's benefited all the North Sea states and their citizens. We don't have oil on our beaches anymore, for example. Now, the coastal states of the South China Sea have cooperated under the wise leadership of Ambassador Jalal, who was one of the giants of the conference. And the declaration they adopted in 2002 is a landmark. Its precise legal status excuse me, may be subject to different opinions, and the efforts to contain, to change the declaration into a code of conduct have been unsuccessful to date. But one can but hope that the efforts will continue through the mechanism of ASEAN plus 1, 2, or 3, and come to some better arrangement than having the present disputes. This would be in the general interest as well as in the interest of the environment and the living resources. Thank you very much.
I thank David for his very precise and illuminating report, and I'm sorry to have asked him to cut it short of parts that are as interesting as those he pronounced. We still have, I suppose, 10 minutes or so for questions and answers to questions. Professor Zhao.
Thank you, Mr. Chairman. Quite interesting and stimulating panel, and I just make some comments and also questions. And regarding the Vietnamese position, and to me, it's some kind of, because there's no express statement from the Vietnamese government, so to me it is still remains ambiguous. And of course, there's one example which can reinforce, which Ted just mentioned, the Vietnam position is the 981 oil rig incident, because Vietnam claimed that the oil rig was located within Vietnam's EEZ, measured not from the Brussels Islands, but from the Vietnamese mainland coast. So this can be reinforced. But on the other hand, in the Vietnam's position paper submitted to the Arbitrary Tribunal in December last year, Vietnam made 3 points. One is the tribunal should have jurisdiction over the case. Second is the U-shaped line is void and invalid. And third one is Vietnamese maritime interests and the rights interests should not be prejudiced by any ruling from the tribunal. So this kind of preservation of Vietnamese interests, it seems to me that because if we look at the facts, and Vietnam also claimed all the islands except the Scarborough Reef and occupied, claimed by the Philippines, also claimed by Vietnam. So there's kind of overlapping claims in the South China Sea, and so it's not very clear. So the Chinese position is also ambiguous, because China made very clearly that Okinawa Shima is a rock, not an island. but China never said that the island, the Nancy Island or Spratly Island is a kind of rocks. And also, on the other hand, China made a statement in the diplomatic note that the Spratly Island is entitled to territorial sea easy and continental shelf. So this is kind of ambiguities existing in the government positions regarding China and Vietnam. This is my kind of own observation. My question is about the geographic features and the islands. This is another thing. Oh, I published an article about that. This is kind of, it's a dilemma about the hybrid features. That means half natural and half artificial, just like those they claimed in the South China Sea also by Japan, currently by China. So how to define all these? Of course, you can say this is artificial islands, but it's kind of the conclusion on the observation could be too simple. And this is the one question to Ted. The other is about to Judge Anderson is about acquisition of territorial sovereignty is subject to the customary international law. And can state claim submerged features in accordance with customary international law?
You mean fully submerged?
Submerged, like permanently submerged.
Like Reed Bank.
Like Reed Bank or Vanguard Bank, James Shaw. And in the context of coastal states' rights and sovereign rights and jurisdiction over the continental shelf, because as we know that when in 1945, the Truman Proclamation, after Truman Proclamation, many countries claimed the continental shelf, but some, even we read the paper, long paper published by Professor Lotpad, the former Lotpad, and it seemed to me at that time, during that time in the 40s, and countries could claim the underwater territories. So this kind of thing. The other thing is because the two judges also attended this third conference on the law of the sea, UN law of the sea, and there's we know the Annex 7 arbitration process, because there's a provision about the default procedure. So what is that clause provision comes out, and what is nationality, national behind the provision? Because usually the arbitration, the basic principle for arbitration is the consent from the country concerned. But this kind of default arbitration, to me, is very curious. You know, it's kind of innovative in the law of the sea convention. Yeah, against the kind of general principle of arbitration in general terms. Thank you very much.
The floor for first to Ted.
I'm going to take two and leave one for David on the hybrid island. Okay. And I'll do the Reed Bank thing. First of all, I haven't actually looked at the December Vietnam paper. I tried to find it, and I didn't, so I'll be coming to visit you in a few minutes to see what Vietnam said. I think Vietnam's very clear. I think their 200 nautical mile zone shows their, unequivocally shows what their position is, even if they haven't stated it in a public statement. In the same way, I think Malaysia's made their position fairly clear, and I think the Philippines, well, they've actually stated it now indirectly. So I don't think there is a ambiguity on the part of Vietnam. I also think it's consistent, as I said, and you'll see that in the full paper I cite Mark, who several times refers to the Vietnam position, that this is their view. Now, I accept the fact that's Mark. That's not the government of Vietnam, but knowing who the author is, it's probably, it has more credibility than me saying it, is a nice way to put it. So I actually think Vietnam is fairly clear on that. The Reed Bank one, yeah, no, I've actually read that article you've got, and I'll disagree with part of it in the actual paper itself. It just seemed inappropriate to have a fist fight here, because I always lose when I talk to you, so I do it that way. But on submarine features, and I looked into that argument, I don't buy it. When it comes to fully submerged features, I think that you have to, it gets into to the definition of the continental shelf. And while there are submerged features, the ones I know the best are in the Arctic, the Alpha Ridge, the Lomonosov Ridge, those types of ridge. People do talk about those ridges being claimed, but the reason that it's not the ridge that's being claimed based on the fact that it's a ridge, it's the ridge being claimed because it is part of the natural prolongation of the landmass. If you don't have the natural prolongation of the landmass, and what I mean here is not the old meaning out of the North Sea continental shelf case, that I mean it under Article 76, and the continental margin understanding of natural prolongation. So you don't get your continental shelf unless it is encapsulated within your geomorphology wording of Article 76. That may include and may deal with certain types of ridges. And you understand, because you've written it as well as I have, under Article 76, the ridges do become part of that. So you don't get Reed Bank because you've claimed it. You get Reed Bank because it is otherwise within your outer limit of the continental shelf. So I don't think you can actually claim, as a matter of law, you can say whatever you want in public. We claim, I'll use Canada, we claim the Lomonosov Ridge. Well, that's fine. But the legality of that claim is based on where the outer limit of the continental shelf is, or the outer limit of the 200 nautical mile zone. It's not the fully submerged provision itself. So in the case of Reed Bank, I'd have to go check. But if that doesn't fit within an article, if that's beyond 200 nautical miles of China, if it is, and it would only become part of China's continental shelf if it otherwise fit within the wording of the criteria of Article 76. It's not because they've claimed it in an abstract sense. So that's my answer to that. I have a pretty good answer too, but if you're interested.
David, and I will say a couple of words myself.
Okay. Well, on the half natural and half artificial question, I recall we built a lighthouse on the Eddystone Rock in the 19th century. And the lighthouse was so big that no one knew where the original rock remained, or what remained of it, because we had to cut the top off to put the foundations of the lighthouse. This issue arose in the Anglo-French arbitration about the continental shelf boundary in the Channel. And in the end, having heard the evidence, the judges threw up their hands and said, well, it's all too difficult, but the French have acquiesced in its use in the Fisheries Agreement of 1964, so they're somehow stopped from objecting to the British wish to use it as a base point in constructing an equidistance line. It was one of the few points that we won in that case. If you have an artificial island, I don't know whether any of you have had the pleasure of going to the Maldives, but you come into land on Malé Airport, which it's like an aircraft carrier from the sky. There's a bit of runway sticking out one way and a bit of runway sticking out the other way, and the terminal is on land in the middle. So that is a natural feature, and the area of the two runways, either end of the runway, is greater, I would say, than the size of the island in the middle. Well, that is clearly a natural island with bona fide public works. Without that runway, we wouldn't be able to take holidays, or in my case, go for negotiations with the government of the Maldives. Now, there may be more extreme examples whereby a state has got title to a small feature and then it decides to turn it into a massive installation. Well, something would depend upon, if the issue came before an international court or tribunal, a lot of evidence would have to be submitted as to the natural state, the status quo ante, and what had happened and what the purpose of the extension was. So I think you'd have to decide on a case-by-case basis whether this remained a natural island or whether the overlaying construction was so great that it had completely obliterated the natural feature, in which case it would have become an artificial feature. I would say that the starting point would be that the feature is natural until the point is reached that it's been made unnatural by the obliteration of the natural. So I think you have to decide on a case-by-case basis. Can I come to your question about claims based on occupation? And you mentioned the Truman Proclamation. Going back a bit further in time, there was a famous article by one of my predecessors in the legal advisors, Sir Cecil Hurst. He wrote a famous article called "Whose is the Bed of the Sea?" And it was all about pearl fishing banks in the days when you had 3-mile territorial sea. And some of these pearl fishing banks in the Gulf, maybe in other parts of the world, I'm sure Professor McManus knows where pearls come from. And Cecil has put forward the argument that title to these pearl fishing banks beyond the 3-mile limit could be acquired by occupation and administration, which are the classic ways for acquiring sovereignty over small islands. However, the Truman Proclamation sparked the process which led to the Geneva Convention of 1958 on the continental shelf. And there was a big debate in the Law Commission and in the literature. You'll find it in O'Connell's book, I think. People like Lauterpacht and Richard Young. There are a lot of articles written in the late 40s about the actual legal status of the continental shelf. And in Canada, you had some constitutional litigation on the point, did you not? Yes. Ted's nodding affirmatively. But I think it's very clear now that once the international community accepted the concept that rights to the continental shelf were inherent rights stemming from sovereignty over the coast and over the natural prolongation into the sea, this natural inherent ipso facto title must have obliterated any residual claim to occupation on the lines suggested by Cecil Hurst. So I don't think a state is entitled to claim special rights over a submerged bank on the basis that it claims the continental shelf. It doesn't have any special claim to the bank. It's the same sort of claim as it's entitled to over the remaining parts of the continental shelf, and it's subject to delimitation with neighbors. It's subject to the outer limit through whatever mechanism. Thank you.
Thank you, David. I would just like to answer briefly to the last bit of the question about how come that in an arbitration system, which should be based on the will of the parties, there are these rules about proceedings in the absence of one party. Well, I don't have a precise recollection of the preparatory work, but it must be remarked that Annex 7 arbitration is not the usual kind of arbitration. It is compulsory arbitration. It is an arbitration of an arbitral tribunal that has compulsory jurisdiction, and even it's the default system on the convention. So it has certain features that make it a little more similar than usual arbitrations to the ICJ or Law of the Sea tribunal system. This is my explanation. Thank you. Are there, maybe we have still time for one or two more questions. Please, young lady.
Thank you, Professor Travis. I want to comment about the position of Vietnam toward the legal status of Spratly Island. I can find that in the letter to Secretary General of the United Nations on 18 May of 2009, Vietnam holds the position that the Spratly Islands do not generate exclusive economic zone and continental shelf, and any other zone around these islands should be limited to territorial seas. So therefore, I would like to say that Vietnam have officially announced the position toward the legal status in Spratly archipelagos. And I have one question that, according to Professor Anderson, islands which is not natural form should be treated as artificial islands. And the article in the convention about artificial islands is Article 60, and states, coastal state can build up or artificial island in their EEZ. But if the EEZ is not determined or classified as their EEZ, it's a disputed area. So other states can other states bring that issue to the arbitration, to the court or tribunal under Article 287 for a provisional measure to stop that action, to stop the activity of building islands in the disputed area. Thank you.
Just a quite brief question. First, I'd like to thank you for the interesting start of the afternoon. The question is mostly for Professor Anderson. I was wondering if an island state would then submerge, this state having only the island as territory, if it fully submerges and we do favor reality, let's say, what would happen to that state then? That is the gist of it. Thank you.
Unfortunately, this is a sort of upcoming problem. Well, it's a problem which Elisabeth Lindgaard and I think, discussed in the International Law Association Committee on baselines, and you'll see the results of that discussion in the report of the ILC for one of its recent sessions. I can't remember where it was, but you'll find it in the on the ILA website. Actually, they don't produce paper reports anymore, but it's all there on the website. And one of the recommendations we made was that the ILA it raised a lot of new, novel issues, and so we recommended that a new committee should be established, on which I certainly am not a member because it's too difficult. But people like David Freestone are grappling with this problem. For what it's worth, my view is that you have to, as I said in my paper, you have to take a stab at the question when it arises, so that if you have a problem now in 2015, you have to look at the situation as it pertains in 2015. If Tuvalu were to be washed away, that would be an enormous tragedy, and the UN would have to rally around, and we'd all have to take some refugees, or they'd have to be resettled somewhere not too far away, I hope, in the Pacific, with assistance from the UN and so on. But if an island, an inhabited island, which is also a state, were to be totally washed away by another terrible tsunami, then it may be a tragedy, but in my view, you have to accept it and do the best you can for the people. But you can't construct a fiction that it still exists if it's gone beneath the waves.
Okay, from the administrative point of view again, there will now be a coffee break in the same room that we had also the lunch and the other coffee breaks. And I propose that we get back at 15 minutes past the hour sharp. So have an hour of coffee break.